Hi, I'm Jim Crawford. I wanted to talk to you today about an issue that seems to be popping up quite a bit throughout the state of Maryland. I do a lot of sex offense type work. I do a lot of child pornography type work. And of course, I do a lot of criminal type work that includes many different aspects of various cases on the state level and the federal level. Something that's been happening a lot in child pornography cases is that I'm seeing in many counties that these state's attorneys, and even on the federal level, are taking a position that if you're caught with child pornography, and if they can prove their case, then they're looking for some mandatory time on the state level. A typical situation would be, for example, in Baltimore County, I've noticed that what they're doing is they're asking that you agree to a plea that would be between 6 and 18 months. And what they're also looking to do, these state's attorneys, is they're looking to prohibit the defendant from requesting probation before judgment, which of course would prohibit you from keeping this off your record if it's a misdemeanor, or even if it's a felony. Under Maryland law, um, uh, the Maryland Annotated Code Criminal Law Sections 11-208 and 207, they are the child pornography possession statutes and distribution statutes. The distribution and manufacturing obviously is a felony, the possession is a misdemeanor. If you were to obtain probation before judgment in these situations, then of course it would be kept off your record. And most importantly, you would not have to register either under Tier 1 or Tier 2 for the sex registry. Anyway, back to my point. The fact that these state's attorneys are requesting these mandatory times means that these cases are becoming more and more prevalent, more and more serious in the eyes of law enforcement. We all have our views about child pornography from the standpoint that it's obviously not a good thing. It's something that's a horrible issue and can be harmful to children and to society, obviously. But there's many various circumstances that put people in a situation where others may believe they possess it when they really don't, or there may be mistakes, or situations where accidents occur where they just weren't deleted. Many times, or at least most times in these situations, what happens is you will basically have a knock on the door early in the morning or late at night, where detectives will come into your house and they will basically look at all your media devices, computers, phones, external hard drives, and they will do a quick check on them and they will take them. Depending upon the county, sometimes you get locked up right there. Sometimes you won't get locked up or charged until later on. If that's the case, many times we can prohibit or prevent the charges from occurring, or at least try to minimize the charges from occurring. So it's not a fun topic. It's not something that people want to talk about. But when law enforcement knocks at the door, you need a lawyer. I advise not to discuss it with the detectives or the police. What they're trying to do is show a possessory interest in the laptop or the computer or the external hard drive. So mum's the word. Even if they play games, they threaten you, they say if you cooperate, we'll help. Usually, the detectives do not have any influence or very little influence with the state's attorney's office about what happens. So when these detectives say to you, well, we'll do this, we'll do that, yes, sometimes it can happen, but most of the time it doesn't. So my advice to you is to not say a word, call a lawyer immediately. I hope this has been of some help. I'm Jim Crawford. Thank you very much.